Yeah, that's fair.
Oh,
Oh,
All right.
there we go.
there we go. All right. So this is our presentation for safeguarding intellectual property for an anti-advertising device. Um, our presentation will outline a few steps necessary to protect IP um, or the IP of our device.
All right. So, first step in creating an intellectual property is basically your research and development of your problem. You need to conceptualize and innovate a functionality or features to basically solve a problem that your particular audience or consumer group is having. After you've come up with some kind of solution for that problem, you need to identify if it is a patent-worthy innovation. Basically, you are looking for novelty and to make sure that a current solution has not already been patented. In order to do this, you have to do a patent search, which a lot of it is for, again, the novelty of the problem. And you also need to look for the freedom of operate and the state of the art search. Freedom to operate means which you don't, in the production or operation of your product, will not infringe upon the patent of others. A lot of this has to go with cross licensing of software or other patented components that your product might use. Biggest one that I have found is software copyrights. So if you make your own software, a good way to get around freedom to operate is to copyright your own software so that you have an innate license to use it. Otherwise, you have to get official license for any software or components used before you can proceed with getting a patent. After all of this has been sorted out, you can then draw up and craft your patent application. Then, once your patent has been given and is in a ready state, you can then begin prototype construction for finalization of your patent to prove that it works. Once that is done, then you can come up with your brand name, logo ideas, and all of your other marketing tools. And then you apply those for a trademark so that those cannot be used without your license and permission. After those have been decided upon, you can then register your trademark, and then that will then give you copyright protections on anyone trying to use your brand name. After that, and it's ready for production, you then go to a variety of possible manufacturers and contract out the labor and part security in order to continue manufacturing your product. And then once it's out on the market, you can then have your IT team and other legal representatives to enforce your intellectual property rights should others try to infringe upon them without given legal license.
Right. Yeah. And so for intellectual property capture, we have to first start by ensuring the unique features inherent in the design. So our device must set itself apart from existing patents. Like Mason just said, it has to be free of any primary sources or fundamental pieces of it that come from pre-existing patents. And we have to be careful about it as the filing fee is $200. So every time we mistake filing, we'd have to go through the process again. And so for the registration and protection, uh, when we patent it, we must use registration of the idea through these means. There are a lot of legal steps in place in case of the protections being infringed upon that must be set up. And we have to have points of contact with legal representatives set in place for when it is infringed and what methodologies are being used in order to uh, regain power over it and use the power of the intellectual property capture that we've previously set up. Okay, and then moving on to the next slide here. For the team communication, we have to ensure that we use lots of training measures because IP protection is a daunting task due to the legal proceedings that you must follow. So in order to do that, we have to have regular training that can ensure the team knows the proper steps. Training and documentation ensure a smoother process, protecting a large array of IP that we must protect. Alongside this general team communication, there's also senior management communication, which is mainly part of informing the senior management because senior management needs to know the importance of intellectual property protection in order for funding to be delivered and the true importance of it to be displayed in the business case. This explanation to senior management doesn't need to be fully in depth of the legal proceedings in order to accomplish the capture of IP. It's mainly just explaining the importance of the IP. And then finally, the role of the IT department is that they are safeguarding the internal assets used inside of the company that give us a business edge. Some of this might be intellectual property that has a patent, copyright, or trademark associated with it, such as software or surrounding softwares that are used in the production or maintenance of our intellectual property. So this is another thing that must be protected here.
And then when we go out to communicate our strategy to our teams, for our general team, we're going to have to communicate to them our IP protection standards so that they know exactly what they're doing and how to do it effectively to not accidentally infringe on somebody else's or to go outside the process map. We'll have to communicate with management to secure funding. And for our IT department, we're going to need to work with them to ensure that they know the limitations of the defenses for our IP, as well as how to protect it from any threats, and to keep it secure from being stolen before it has been protected.
All right, thank you.